Yep. Go to here.
And welcome to this inquiry. And I just wanted to confirm it's Ms. GLENYS OOGJES is there?
Yes.
Okay. And Ms. SHATHA Hamade?
Yes.
Great. So I'd like to welcome both of you from Animals Australia, who is joining us by teleconference. My name is Mark Pearson, and I am the chair of the Select Committee on Animal Cruelty Laws in New South Wales. I would just like to help set up the scene for you here. We are here in the Macquarie Room at New South Wales Parliament, and I have with me the 8 other members of the committee. The Honourable Lou Amato, I'll just presume Honourable, Mark Benasiak, Abigail Boyd, Sam Faraway, Matthew Mason-Cox, Walt Secord, Mick Veach, and the Honourable Emma Hurst. Members of the public and the media are also present, and the proceedings are being recorded by Hansard. Could you state your full name and job title for the record and take either an oath or an affirmation?
Thank you, Mark. My name is GLENYS OOGJES. I'm the CEO of Animals Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me will be the truth, the whole truth, and nothing but the truth.
Thank you very much. And Ms. Hamade?
My name is SHATHA HAMADE. I'm legal counsel for Animals Australia. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And would either of you or both of you like to make a short opening statement?
I would. Thank you, Mr. Pearson.
Thank you.
Animals Australia welcomes this inquiry and its examination of animal welfare standards and compliance and appreciates this further opportunity to provide input to the inquiry. Mr. Chair, we need to look no further than the current bushfire crisis to see the depth of feeling in our community, the importance of assisting the vulnerable, whether they be people, animals, or indeed our remnant natural environment, all caught in the path of these unprecedented fires. We, like other charities, have been overwhelmed by the support pouring in to assist the rescue and recovery. It is simple. When people see suffering, they want to relieve it. The Prevention of Cruelty to Animals Act in New South Wales and the framework it provides to protect animals from cruelty has been in place for decades, as you know, and it's crucial that we consider whether it's still fit for purpose. That is, to prevent cruelty and to promote animal welfare, to protect vulnerable animals from pain and suffering. That's the contract and that's the expectation of our community. That's the expectation they have for this important piece of legislation. We have 2 primary concerns, which I'll indicate briefly, in regard to the effectiveness of the FOCTA, as we call it in New South Wales. First, the current animal welfare laws are inadequate in themselves, and in particular, that the Act does not treat all sentient animals equally before the law, with the entire classes of animals remaining essentially unprotected from harm and cruelty. Most significant example of this is the inadequate protection afforded to farmed animals, where compliance with voluntary agricultural codes of practice provide an exemption from the cruelty provisions of the Act, that is, Section 34A of the Act. The adopted codes of practice provide only a minimum standard and have, for decades since the 1980s, merely reflected usual, routine farming practices. Animal welfare science and community expectations have been largely ignored in those codes, regardless that they've moved on so much in those decades. And thus this huge class of animals, and farmed animals, have inadequate protection from cruel practices in New South Wales. This exemption to the Act, as an example, for farmed animals provides and allows for practices that fall way below expected community standards. For example, surgical procedures without pain relief and tight, restrictive confinement, such that almost all natural behaviour is impossible for entire lifetime for some animals. Therefore, the Act, in our view, is not fit for purpose for all animals. And secondly, briefly, the second primary concern is the clear need for additional resources to enable adequate monitoring and enforcement of the existing animal welfare laws and regulations. But this task in New South Wales is largely left to 2 non-government organisations, primarily using charitable donations to fund the work, is in our view totally unacceptable and inadequate in our developed nation in 2020. Animals Australia stresses the importance of adequate government funding being allocated to enable the full investigation of animal cruelty complaints, regardless of the organisation's tasked with enforcing the Act. The provision of a sufficient number of animal cruelty inspectors and the resultant necessary prosecution costs should not be reliant on charitable donations from the public. So in conclusion, Mr Chair, Animals Australia believes the Act itself, and specifically the breadth of animals and animal use activities it covers, must be reviewed and updated. We've therefore recommended to this committee, to your committee, that there be established an independent office for animal welfare to assist with the support, improvement and oversight of enforcement activities to achieve the purposes, the original purposes, the existing purposes of the process. We note in this regard that the recent, and I mean by that October 2019 report of New South Wales Parliamentary Inquiry into the use of vacuum cages for layer hens, its first recommendation was that the New South Wales Government establish such an independent Office of Animal Welfare as a distinct authority, separate and independent from the New South Wales Department of Farm Industries, to be responsible for animal protection issues. And that is a quote from the recommendation. So we would commend this recommendation to this committee and suggest the issues raised by us and other animal welfare advocates and submissions to this current inquiry could be considered and advanced by the appointment of such a body. The community expectation of a strong safety net for all animals in our care is, in our view, not currently being fulfilled, and we seek the committee's assistance to enable a robust process of reform by such an independent Office of Animal Welfare. Thank you.
Thank you very much, Ms. Oogjes. And Ms. Hamade, do you have a statement that you'd like to make?
No, that was a collective statement. Thank you.
Okay, thank you. The Honourable Walter Cord is going to ask a question.
Thank you for your submission, and thank you for your introductory statement. I'm Walt Secord, the Australian Labor Party. Now, I just want to note that at the 2019 state election, we actually went to the election with a policy of an independent Office of Animal Welfare. So we welcome your recommendation. Now, putting that aside, so are you critical of AWL and the RSPCA, or is it the fact that you're critical of the lack of investigation in your view? So is it a criticism of those two bodies, or is it a criticism of the regime that's in place?
It's the latter in our view. We're not here to criticise. We don't have a criticism of the existing two charitable organisations that are doing their best, we presume, to enforce compliance and to respond to the very many complaints that they get. Our view is that it should be the government should properly fund all authorities under the Act, and of course, such as the police and others, to undertake a more robust and broader approach to animal cruelty issues. We don't think it is right that charities, and not even fully funded charities, have to use community donations in order to undertake both inspections and compliance activities and prosecution.
Thank you for clarifying. Just one last question before I move to my colleagues. So how would you see an independent Office of Animal Welfare working, and who would you see it reporting to?
Thank you. In our submission, we've gone some way towards answering that, indicating the sort of things that we do.
Yep.
Just to answer the last part of your question first, we believe it should be lodged, that is, it should be an independent office lodged in a department that does not have any perceived or other conflict of interest. We believe the Department of Farm Industries in New South Wales, similarly in other states, do have conflicting priorities, and so we don't believe it should be there. We would expect it should be under an independent department, such as the Auditor's Department, the Premier's Department, a department such as that.
Are there any other international jurisdictions that have what you think is sort of best practice that you would point to?
Not in the same way, that we're, not to our knowledge. There certainly are systems such as in the UK and Europe where there are independent panels, particularly scientific panels, that assist in the process, that is providing independent, well-based recommendations to government. So there's certainly some of the elements that we see in this in an independent office in other jurisdictions. But no, we are seeing this as a more broad-ranging office that would look at providing expert advice to government, but also facilitating, for example, the development and setting of enforceable animal welfare standards based on scientific input and practical knowledge, and to be able to assist enforcement bodies across the board, enforcement bodies to increase training and readiness to inspect and to, where necessary, educate and sometimes prosecute. So we are looking at it as a one-stop shop, if you like, to be able to improve both the review of standards, but also to then enforce those standards.
Thank you very much.
Just for clarity, to elaborate there to an extent, since the proliferation of factory farming or intensive farming, where we have what one would call, I suppose, the hidden animals, do you think that a review of whether charitable organisations with limited powers is now in question because of so many animals being kept together in a space where they cannot be easily seen, and yet still reflecting the provisions of the Act, which is protection for every individual animal?
Well, you're quite right, of course, that the animal POCTA sets out in its purpose to protect all individual animals. But as I indicated, well, in our submission, but also earlier, so many animals don't have sufficient protection. The standards that they are required, that their owners are required to comply with relate to codes of practice that are not fit for purpose, meaning that they have not changed over the years to properly reflect animal behaviour, the known and scientifically known natural behaviours that are required. And so, yes, we are concerned that there are very many animals suffering. There is not an adequate inspection regime, routine or otherwise, to our knowledge, in the jurisdiction. And so it's a real concern that there is not that oversight, and we believe that there needs to be a much greater compliance enforcement body in place.
Thank you. Just handing over to Mr. Banasiak, or the Honourable Mark Banasiak.
Yeah, thank you. Just sticking with this independent authority, in your submission you state that it would be a New South Wales-based statutory authority, either in the Attorney General's or Premier's Department, but you would also have Commonwealth Government members there as well. So I'm just interested in terms of how you think the lines of authority would work when you've essentially got federal government members essentially being subservient to a state Premier.
If that was the impression we gave, we don't really mean that. Certainly...
You explicitly said Commonwealth Government members.
There's certainly several things going on, and there is if you like, incentive to have nationally consistent standards, and so that's where the Commonwealth Government would come in. As you probably are aware, they don't have constitutional authority as such, but their input would be sought, I'm quite sure.
Okay. Who was the author of this submission? Was it yourself or was it a joint submission? Because you, in one of the footnotes, you referenced the author in relation to code reviews. So I'm just wondering who. It's just a bit of an unusual reference. It's a bit like referencing talking to a mate down at the pub. If there's no background to it.
My apologies for that confusion. That's my note, if you like. Yes, we did it jointly, but I wrote that section, and it relates to my long-standing work towards the review of codes and standards and legislation for that matter. I've been involved in the animal welfare movement since the 1980s. I've been on committees, both federal, animal welfare advisory committees, federal and state throughout those decades, in fact. And I've been around the table for the review of national standards, which become, as you all know, the codes that each state takes up or doesn't, as the case may be. So I have been involved around the table in the review of the transport standards, the cattle standards, the sheep standards, the poultry standards, the sale yard standards. I could list them all for you. And what I can tell you is that those standards have not moved significantly or indeed virtually at all since they were introduced in the 1980s. At that point of time, in the 1980s, they simply documented, and indeed animal welfare organisations in the very early 80s were not around the table, and they simply documented the current way that things were done. That is, surgical installations without pain relief. The battery cage system, of course, was just documented at the time, and that has been the case all the way along. And even in the 2000s, when the more modern reviews have been undertaken with us around the table, even scientists around the table, it has been the farming industries in each case that have, if you like, said what they required, and because of the system in place right now, which is agricultural ministers signing off on these codes and standards and guidelines, that they have got their way. In other words, that is why there has been virtually no change in the standards. That is why there are gaps in the protection of animals when it comes to farm animals in our state legislation, including the New South Wales FOCTA.
Yeah,
Sorry, just for clarification, are you saying that is why, one of the reasons being why is that it's the Department of Primary Industries or Agriculture in which animal welfare portfolio sits?
Yes, we're very concerned that is the case because an agriculture minister state, and then when they collectively come together in what is called now AgMin, the problem with that is that their constituents, the farming bodies that they are in place to assist to develop their industries, have a conflict with sometimes animal welfare, which of course can mean change in practice and certainly should mean changes in practices. And there is a real reluctance on the part of sometimes the departments as well, but certainly the ministers, to give way to change. They may then get, if you like, backlash from those others that they are trying to represent, farming and other industries related to farming industry. So there's a real conflict, which is why we're suggesting that independent Office of Animal Welfare is required, and why it should be in an independent department or reporting to an independent minister or Attorney General, as we suggested from the Premier. Just
back to the other mark again, you were fairly critical about the New South Wales farmers and their involvement in getting a word changed in one of the codes and changing the word from competency to having relevant knowledge, skills and experiences to complete a task. Given if you look at every definition of what competency means and you look at the Interpretations Act, it references that competency means having the knowledge, skills and experiences to do a complete task. So I put it to you that in that criticism, you're really splitting hairs in terms of that.
Can I indicate to you that is, from sitting around the table, across the table from those debates, it really was because the farming bodies, in this case New South Wales farmers, were concerned that farmers may be judged incompetent. And so, yes, splitting of hairs if you like, but certainly it was, I think, a real reflection, and to some extent it demonstrates the concern that farmers, farming industry groups at least, representing farmers, are really so concerned about anything at all changing. Competence was used in previous codes, and that is other species codes, and it was only when it got to particularly the sheep and cattle standards that this became an issue.
Hi, Glenys. It's Emma Hursty from the Animal Justice Party, and hi, Shatha Hamade as well. You advocate for an independent office of animal welfare. We've got other submissions recommending that the model should move to, an animal cops unit. And I'm wondering what was the reason for your preference for an independent office of animal welfare, or if that's just where you went, or whether you actually have a specific preference for an independent office of animal welfare.
Sorry, Emma, you cut out there. What was the alternative suggestion? An animal...
Like an animal cops unit as a specific designated area of the police force was the other thing that's been suggested today.
So really you mean, that suggestion is related to having police involved in task force situations?
Yeah, so our last person that came in to give evidence was talking about the best model going forward was to have the police force be the primary prosecutor and investigator for animal cruelty, and for the police force to have a specific unit to investigate and prosecute animal cruelty, which is slightly different to an independent office of animal welfare. So I was just curious as to whether you'd looked at both models and if you had a preference for one over the other.
Could I say, Emma, that we would be supportive of the police having such a task force, and I'll ask Shatha to speak to that in a moment because we've had experience with that. But I don't believe the two things are mutually exclusive, meaning that when we talk about independent Office of Animal Welfare, you'll see in our submission it's quite broad-ranging, including developing standards and helping with training and such things across the board. We would see the Independent Office of Animal Welfare sitting above all of those elements of review of standards, assisting with changes to legislation, reporting and training, as I said, and overseeing the compliance system. And a police task force or the use of the police in any way, we would see that as just part of the whole, that is part of the various agencies that would help with enforcement. But Counsel, would you like to speak to the value of having the police experience involved?
Certainly. Well, I guess the real-life case study of that was the creation of the Queensland Task Force to look into the greyhound racing industry in Queensland. That was the formation of a task force with police skills and experience that were then basically trained up and charged with looking after that particular portfolio. And so, with the full gamut of powers in terms of surveillance and enforcement, etc. And of course being backed by a government agency, in that not being reliant on charitable funds, so that, everything can be progressed on its merit, on the facts, rather than needing to worry about budgets, etc.
And with an independent office of animal welfare created, do you see the RSPCA and the Animal Welfare League continuing as an enforcement agency under POCTA as well? Would they still have a role to play in your idea of an independent office?
Yes, we do believe so. We believe that there could be a number of different organisations or authorities, departments, for example, involved. And there would be benefits. For example, and I assume it's the same in New South Wales, the Victorian fisheries, for example, have a compliance arm. And we see the idea, well, not the idea, but the plans in the Office of Animal Welfare to ensure that there is good and consistent training of each of those agencies so that they can work in a consistent manner. And they will have expertise in different areas. Of course, the police would be able to deal with things that are more along the criminal, that is the organised crime and gambling and such things, areas, whereas the existing RSPCA and Welfare League may have greater expertise in regard to domestic animal issues. So I think they all have a role to play.
Thank you. Mr. Waltz-Court?
Yes, I just want to thank you again for making a comprehensive submission. Now, I know that there's widespread interest in the proceedings, and I know that the land, for the benefit of the National Party, it's a publication that comes out on Thursdays, that there is considerable interest in this, but do you have much engagement with the National Party? Because I noticed that on this committee here that there's been no questions from the National Party to you about this. Do you have any engagement other than, and I would take their silence to be a support for your submission, that do you have any, any comments or any engagement with the National Party?
Not on a regular basis. That's not different to any other political party, if you like. We're a charity. We deal directly, usually, with the Departments of Agriculture or the ministers. So it's not usual for us to have frequent contact with other MPs.
Now, in one of the very first bits of evidence we had was from the Department of Primary Industries, DPI, and they announced that the minister and them are on the verge of announcing, they said, a quote, once-in-a-generation review of animal welfare involving POCTA, Exhibited Animals Protection Act, medical research, and the Crimes Act. So will you be making submissions into that area? Because one of our recommendations, one of our areas of our terms of references is and related matters. Well, if you were looking at other areas of animal welfare, what would you be looking at?
As I say, we're not. I'm not exactly sure what department is projecting it's going to be talking about. We do know that the federal government, with the involvement of the states, is going to look at a review, a significant review of the way farm animals codes of practice and standards and guidelines are reviewed. But I don't know more about that yet because it hasn't been announced. We will, as we have for some decades, be very keen to provide input to any such review, and we'd welcome a review because, as we've said, we don't believe that, the New South Wales Act at the moment is fit for purpose, and that is not dissimilar to the situation in other states. And I'm sorry, I missed the last part of your question.
I just referred to the four areas. The Director General of the department actually said it was going to be a once-in-a-generation review of the four main streams. And there was like POCTA, Exhibited Animals, Medical Research, and the Crimes Act. So he was promoting it as one of the biggest reviews coming up in animal welfare.
Making Glenys and I feel a little bit aged.
Okay. Anyways, okay, I'll move on to, so that was the end of my questioning. Thank you.
Okay, to Mr. Banasiak.
Just on page 3 of your submission, you state that significant work is needed to raise animal care standards. But on page 1 of your submission, you state you have no direct insight into monitoring, reporting, investigating and prosecuting animal welfare in New South Wales. And in the next sentence, you can contradict yourself when you state the laws are inadequate. So I'm just wondering, what do you base your assumption that significant work is needed if you have no direct insight into how the laws are working in New South Wales?
We've quite upfront, of course, indicated that we don't have a direct insight into how it's happening. Indeed, we can say that in any state because it's very difficult without adequate data to know what's going on, I have to say. But what we have said is that the Act itself, as I indicated, carves out whole classes of animals from its direct protection, that is, protection against cruelty as is in other sections of the Act. And so that's what we meant by that. I don't believe it's a contradiction.
So if we get this independent statutory authority up and it looks at all animals and no animals are cut out, as you say, would Animals Australia be happy then to say that the laws are adequate, or is there further work that you think that needs to be done? I'm just wondering, in terms of Animals Australia, what's your end goal in terms of animal laws? Are you looking? Obviously,
it's hypothetical to some extent because we don't know how extensive the changes to the Act would be, but we certainly recommend changes to the Act. Having said that, once it will only be as good as the compliance and therefore the education and activities of the authorities in order to ensure that people live up to that standard, that is animal carers and owners live up to that standard. And so I think there's an awful lot of work to be done even once a full review of the Act has occurred. The other element too is to understand that in order for it to be fixed, there are significant areas such as currently covered by codes of practice in New South Wales that have to be significantly changed.
How far do you propose? You say that great swathes of animals are not included. How far do you propose that we delve deep into it in terms of animals? Are we talking every single animal? Were we talking fish, crustaceans, insects? Like how deep do we go in terms of the animals that we would include in this review of the Act?
Well, this comes down to the fact that, well, it's a question of sentience. If an animal has the capacity to suffer, then that animal should be afforded protection. But this question that you raised is really a fundamental question and is what GLENYS alluded to in the beginning about the fact that much of these regulations or codes haven't moved much in many, many decades because of the inherent conflict of interest of those charged with administrating them and developing them. And so what we are saying is that we're now in 2020. There needs to be an entire overhaul and modernisation of these laws, and it's also about the principle of proportionality. Back in the day, the sort of suffering that was inflicted on animals, particularly in husbandry, may have been deemed reasonable or acceptable because of lack of science and lack of resources. However, in 2020, the advancements in science, the advancements in community expectations, and the availability of additional options for advanced husbandry are now readily available. And so the proportionality question now shouldn't be about what maximises profitability. It is the suffering of these sentient animals necessary in the face of what we now have available to us in science and resources in order to alleviate that suffering, keeping in mind that necessity should not be about maximising profits when you are dealing with sentience.
I have a genuine question here about sentient creatures. No, I didn't mean it like that. No, I mean, well, actually, a question of sentient creatures, because I've actually grappled with this. Animals Australia, so when it comes to animal protection, I guess in the animal kingdom, how far down do you actually go on sentient creatures? Do mosquitoes, as Mark asked in his question about insects, how far do animal rights go? I'm asking a genuine question. In your organization, how far down do animal rights go? Do they go down to mosquitoes, ants? I'm curious.
Look, we have to take a practical approach to this, but we also follow the science. And so where sentience, that is the ability to feel, to suffer, can be shown, reasonably shown, meaning that it's fairly well agreed that an animal is able to do that, that is sentient, then we believe they should be protected. That's already been considered in a number of documents, of course, including the NHMRC National Code of Practice for animal use in research and teaching, for example, tried to look at this in regard to the development of fetuses and animals that at least halfway gestated, if you like, are seen to need protection, those sorts of things. But each of the state governments has looked at this when they've defined what is an animal, and of course, usually it goes down to some of them are now protecting crustacea and some cephalopods, and so when that can be shown that they are sentient, they should be protected. And so I would say that, for example, most fish are now understood to be able to suffer. That is, and so they certainly should be looking at fish and other animals that there can be agreement that they have the capacity to suffer. That is what a Prevention of Cruelty to Animals Act is about, that is to stop suffering or to prevent suffering.
As Australia's leading animal protection organisation, have you ever requested from the government to become one of these ACOs that would enforce the POCTA Act?
No, we haven't. We don't see that as our role. We certainly do see our role as to to assist and urge others to do that, to take on that role and do it well.
Thank you very much, Mr. Mason-Cox.
G'day, I'm from the Liberal Party. I might be having a steak for lunch, so don't hold that against me. But I wanted to ask you, in relation to the model codes of practice, I note, and I think you mentioned, that they're being reviewed at the moment, and that animal welfare standards and guidelines will be substituted for them in due course through a COAG process. You're aware of that, aren't you?
Yes, it's a continuous process that's been going on for about 10 years, that change. But yes, various codes are under review at any one time.
Okay, I wanted to ask you, in the suggestion that you have for an independent office of animal welfare to set up standards, would that office under that model be in competition or potential conflict with the COAG process that's undergoing a wide review at the moment?
We would, no, I don't think so. Timing-wise, it wouldn't be. We're hopeful that the review at the national level, that is having a look at how codes and practices and standards are reviewed, would be happen through this year. And in any event, there's always good cooperation and liaison between the states who have the constitutional power for animal welfare with the federal government in Department of Agriculture, particularly in Canberra, in order to ensure some national consistency where that's possible. And so I don't think there's any conflict at all, that they would work in concert.
So you accept that we're better to have a national process in relation to these codes of practice over time, which will...
I think you need both. That is, you need a good and robust system, an independent system at the federal level, and you also need it in each of the states and territories. And I don't think there's conflict there. I think the two levels can work in concert.
Well, I'd like to see that happen, but I think what I'm trying to get at, you couldn't have a model code, for example, in relation to battery hens and the production of eggs or processing of chicken, and have a state code which did the same thing. That's what I'm trying to get at. You do?
At the moment, while, as you called it, the model codes, and indeed there are national standards and guidelines now for various species, they exist, but they don't have any legal force, if you like. They are just cooperative documents. What then happens in the past and still now is that then a state decides how they will take them up. They are encouraged at the federal level, or that is the cooperative level of all the states, to as much as possible, adopt the national standards. That's why they were called model codes in the past, so that there isn't inconsistency, so that somebody on one side of in New South Wales going to, for example, in a truck going to Victoria, doesn't have to change the way they do things because of the legislation. So it makes sense for there to be cooperation. And as I say, I don't see that that's a problem. We've been doing it for a very long time.
You in the land as well.
Thank you very much, Ms. Abigail Boyd.
I just wanted to ask about this idea of, the exclusions under POTCA and the I think what seems to be a bit of a fear from some that if we include farm animals and other basically other categories of animals within that act, that somehow that will lead to a vegan uprising and an assumption that if you can't eat your dog, then you won't be allowed to eat cows either. And I know that sounds ridiculous, and it is, but that is the thing that people are saying. Could you explain the difference between, I guess the notion of cruelty and how cruelty and a animal cruelty law applying to farm animals would apply in practice?
Yes, perhaps, thank you for the question. It's a key one. I think that what we are saying, and perhaps there are a number of examples, but perhaps one, for example, you would not, it would be an illegal act in New South Wales and elsewhere to move your dog. Now, that sounds ridiculous to everybody. That is to actually cut the skin off the backside of your dog without pain relief, for example. But you are allowed tailed off a lamb without any pain relief whatsoever. What we're saying is that the rules can be the same. The animals can feel pain in a very similar way and will suffer from that wound. It should be similar. That's what we're saying. At the moment, the carve-out means that a sheep is treated completely differently to the way any other member of the community would be able to treat an animal that it cares for or owns.
So the focus is really on unnecessary suffering and preventing unnecessary suffering, as opposed to, trying to extend it to say that, you can't slaughter cattle.
Well, that's right. This is an animal welfare or an animal protection act. So it's just as, and so it's really self-evident, I think, that we are talking about reducing suffering.
Yeah, indeed, and this is back to the point I made earlier. These shouldn't be codes of convenience. These, for producers, these should be animal welfare standards that are based on suffering. Again, not convenience or profit. And we are now in 2020. We have the science, we have the means to prevent this unnecessary suffering, but our codes and our regulations and our laws are still stuck, decades ago. And this is where the work really needs to be done.
Can I quickly just, before I know we're running low on time, sorry, this is Emma Hurst again. A lot of what's come up is around the lack of funding that charities are being provided by the government to uphold this form of criminal legislation, and the unusual situation we have where this is potentially the only criminal legislation in New South Wales that's being expected to be fundraised from the public. Do you think, can you sort of explain what your thoughts are around the government's responsibility to fund the upholding and enforcement of this criminal legislation, and if you've got any thoughts around that funding and how it would work?
I think any other legislation, virtually any other legislation that is put in place, whether it be child protection or landlords of various sorts, they are regulated, and the funding for the compliance and prosecutions, if they're required, is all undertaken by the government. It seems quite ridiculous to us that animal welfare is not funded in a similar way, and indeed that charities expected through community donations to do that work. It is an act of in this case, the New South Wales Parliament, and it should be the government that ensures that it's complied with.
Okay. Well, thank you very much, GLENYS and SHATHA. I think we've finished our questions there. I don't think there are any questions on notice for you to answer in 3 weeks, so that's covered that field. So I think we'll need to close it there, and I really appreciate your evidence for this inquiry.
Thank you very much. Thank you.
Okay, thanks.